Good morning. I think we can start because it's time. So let's invite the administration in. Good morning. Yes, perhaps I can introduce the officials to members. We have Ms. Shirley Kwan, PAS for Financial Services and the Treasury, Mr. Chu-Kwok-Kit, Deputy Commissioner, IRD, Ms. Alice Choi, Senior Government Counsel, Department of Justice, and Ms. Queenie Wu, Government Counsel, Department of Justice. So I think we can look at the Vietnam order first. Yes, thank you, Chairman. Thank you, members. So we have two orders before us, one relating to Vietnam and the other one the Republic of Korea. Perhaps I can say something about the policy background. I believe members are familiar with the subsidiary legislation in this field. Members here are all familiar with the rationale. Yes, as I understand. Now, in fact, since the establishment of the SAR, we have been proactively negotiating CDTAs. And we hope that through the CDTAs, we can enhance transparency in the taxation regime and step up cooperation with other countries in the world. And these two orders are fully in line with our policy objective. The Republic of Korea order is a new CDTA. It was signed with the Republic of Korea in July this year. And the details or the arrangements are clearly delineated. And with regard to royalties, dividends, or tax on royalties, tax on dividends, the withholding tax rate has been adjusted downwards. And then we hope to converge with international standards in respect of transparency of the taxation regime. And that's why we have provisions concerning exchange of information, or EOI. In fact, the administration is concerned about taxpayers' privacy and the confidentiality of any information concerned. So there are very prudent safeguard measures put in place in the CDTAs. Members can refer to Para 10 of the legislative brief on the Korean order. So all these safeguards have been incorporated. The area of exchange of information is restricted to taxes covered by the CDTA. And the order, or the other order, relates to Vietnam. As early as in 2008 December, a CDTA was signed with Vietnam. In January this year, we signed the Vietnamese second protocol with Vietnam. the purpose is to enhance the exchange arrangements so that they can meet the latest international standards. The agreement with Vietnam was signed in 2008, and the area of exchange of information was restricted to where there was domestic tax interest at stake. As members may recall, in 2010, the Inland Revenue Amendment Ordinance 2010 came into effect. And the domestic tax interest requirement for the purpose of EOI was removed. And so we hope that we can now converge with international standards in this regard. And so the Vietnamese order mainly deals with arrangements in relation to EOI. Chairman, is it that I should deal with members' questions first? Perhaps I can pause here. Yes, I'll see whether members have got any questions. Mr. Leung. As I can ask questions on both agreements at the same time? Yes. Yes, thank you, Chairman. Is it that the purpose of the two orders is to update Article 24 or the article on EOI? Is it that the Korean agreement has only been recently signed, and the Vietnamese agreement was signed in 2008, right? So is it that the EOI provisions in these agreements or orders are broadly similar to the relevant provision in the OECD standard, or is it that there are major differences? Yes, thank you. The Vietnamese, or rather the Korean agreement is a new agreement, and the Vietnamese protocol or agreement is an updated agreement. So we've mainly based ourselves on the OECD standard. But then we understand that members are concerned about the safeguards put in place. And so we do spell out clearly the arrangements. May I refer members to para 10 of the legislative brief on the Korean order. Para 10 A to F. Members may refer to those. Now, in fact, this is the ninth order, or ninth batch of orders before members. Now, for the Korean agreement, that's Article 24 for EOI. So we will only exchange information upon receipt of requests. And neither side has the responsibility for automatic exchange of information. And also, the information sought should be foreseeably relevant. And then C, information obtained should be treated as confidential. In other words, the information received has to be kept confidential. And then D, information will only be disclosed to the tax authorities and not for release to their oversight bodies unless there are legitimate reasons given by the CDTA partners. In the past, during our negotiations with our partners, we were aware of the fact that sometimes there might be legitimate reasons for release of the information to the oversight bodies. But then in this Korean order, information can only be disclosed to the tax authorities and not the oversight bodies. Then E, information requested should not be disclosed to a third jurisdiction, and that's in the last sentence of 24.2, Article 24.2. And then finally, there is no obligation to supply information under certain circumstances, for example, where the information will disclose any trade, business, industrial, commercial, or professional secret or trade processes, or which will be covered by legal professional privilege and so on and so forth. And that's in Article 24.3. So I want to point out that these safeguard measures have been incorporated. 24.1.
Article 1， 即係 Article 1就係即係嗰個Treaty Article 1啦。咁其實呢一個
And that's Article 1 of the treaty. I want to know what you mean. Concerning persons covered. If the exchange of information is not restricted by Article 1, then what does that mean? Does it mean that you can provide information to non-residents of the two places? Yes, Chairman. In the OECD blueprint, it says not restricted by Article 1 and Article 2. We've deleted the reference to Article 2 to show that the EOI arrangement can only apply to taxes referred to in the agreement. And for CDTAs, apart from EOI arrangements, there are also tax concession arrangements. And these will only apply to residents of the two places. With regard to Article 24, as in international standards, what is meant by not restricted to Article 1 or by Article 1 means that the information, or if the information doesn't relate to the residents in either place, the request can still be put forward. But then we have to make sure that we can comply with our taxation information disclosure rules. In other words, we need specific information. For example, what sort of information is sought, and that local means have been exhausted to secure the information, but in vain, and so such a request can be put to Hong Kong.
Does that mean that if Korea could ask Hong Kong to provide tax information in relation to a British citizen, and the taxes covered in both the Hong Kong and the Korean legislation? Mr. Chiu, thank you. Why is it that the EOI is not bound by Article 1? The simple reason is that, let's say, the Korean authorities are investigating into a particular transaction which involves a British enterprise which has a branch in Hong Kong. In that case, that branch office is not a tax resident of Hong Kong, is not also a tax resident, but it just so. But then it has an office in Hong Kong. Under the circumstances, the IRD can. Well, in that case, I think this will satisfy all. If it satisfy all the conditions, then Korea can ask the IRD in Hong Kong about the situation relating to the tax residents from Britain. No further questions, Chairman. Now, Chairman. these two agreements, could you tell us how do they differ from the agreements that we've signed with other jurisdictions? Thank you, Chairman and Mr. Leung, for your question. I don't know whether Mr. Leung is also referring to the EOI arrangement. Now, to put it simply, one could say that they are the same. There's no difference. In paragraph 10 of the electrical brief, and the measures listed there have always been consistently adopted in the tax orders in Hong Kong. So there's no particular difference this time. Coming back to the Korean order, I don't think there's any difference in terms of the exchange of information. But regarding the CDTA agreement, is there any particular point that you would like to draw our attention to? That is from paragraph 1 to 9. Chairman, perhaps I can ask the ILD to briefly answer the question. Chairman, regarding the CDTA agreement, both parties have relief measures. I think our relief measures would follow the Hong Kong Inner Revenue Ordinance. As in the case of Korea, according to Article 21, they would follow their own Korean legislations. If we look at Article 21 in Para 2, you would find that in Korea they have two methods divided into 2A and 2B. 2B is about the underlying credit. That is, Korea will give the undertaking that in respect of waivers for dividends, they would look at the Hong Kong company paying the dividend. If that company has paid tax, they will also take that into consideration. Company paying dividend. In other words, Korea has its own local legislation. Supposing that we have a tax on dividend in Hong Kong when in fact we don't. Now, in Korea, Korea will have a tax on dividend. So in this case, they would deduct the withholding tax on dividends, and if the stake is more than 10%, then they will look at the Hong Kong enterprise and the profit tax paid by the entity. So it's not just dividend, but also the profits tax. The precondition is that the stake would need to be more than 10%. So this is rather, unique, and it's also, to Hong Kong's advantage. Chairman, what is the outcome of the public consultation? We understand that there are Korean enterprises setting up offices in Hong Kong. Have you consulted their views on this order? Thank you, Chairman. In the past, the ILD's approach has always been that when it negotiates with a particular jurisdiction regarding these agreements, it would announce on its website that on a particular day it will be starting such negotiations with the jurisdictions concerned. And that would be the opportunity for individuals and deputations to submit the views to the ILD. In the past, we do have a platform. We have a tax issues liaison group attended by representatives of Chambers of Commerce, Society of Accountants, and so on, and they would make use of that platform to reflect the views and express the concerns. Basically, we already have certain standing arrangements in place to gauge the public or the trade's reaction to these proposals. Regarding paragraph 7 of the legislative brief, if a Hong Kong resident has earns an interest in Korea, and that has been reduced to 10%. Does this mean that let me give it, for example, are we talking about bonds held by Hong Kong residents? Nowadays, many people nowadays would buy high yield, bonds or funds which invest in high yield bonds. The entity holding such bonds may not be a Hong Kong resident, but sometimes the entity may ask the Hong Kong residents to declare their nationality, and a certain withholding tax would need to be imposed. Is the Commissioner aware of that? Say if you buy particular funds, which invest in high yield bonds, then the fund manager will ask the bondholders. They will send out questionnaires to the bondholders to ask whether the certain declarations will need to be made in respect of those bonds. Putting it the other way around, even though the fund holds such bonds, would the fund manager have to also find out about the nationality of the bondholders and whether or not they are entitled to certain concessions in order to avoid double taxation? Or is it the case that so long as the bondholder is not a Hong Kong resident, then it will not apply? Regarding the agreement between Hong Kong and Korea, obviously it would apply to Korean residents and the Hong Kong tax residents. The definition of a tax resident is defined in paragraph 3 of the agreement under general definitions. F. A person includes a person, a corporation, a trust, and a partnership. In other words, under this agreement, that both parties have agreed that a trust would constitute a person. The next question to ask is whether or not it's likely that a trust is a Hong Kong resident, and for that we have to refer to Article Section 4, 1A Roman 4. According to the laws of Hong Kong, if the fund is set up under the laws of Hong Kong, or if it's not set up under the laws of Hong Kong, but the manager or the person who controls the fund is in Hong Kong, then he would be a Hong Kong resident. In other words, if you have an investment fund set up in the form of a trust, and if the manager or the controller is in Hong Kong, then according to the agreement, both parties will agree that it is a Hong Kong tax resident and therefore be entitled to the waivers and concessions under the agreement. Using an extreme example, let's say the fund is matched in Hong Kong, but very few of its fund holders are residents of Hong Kong. So the units held by the Hong Kong residents, holding such Korean bonds, would they also benefit? Well, in the course of the negotiation, we asked the Korean authorities to consider the actual circumstances of Hong Kong, Hong Kong being an international financial center, and there are many investment companies in Hong Kong set up in different forms, including setting up in the form of a trust. The Korean authorities have considered this for a long time, and eventually they accepted our view. But I must also add that in this agreement, both parties agreed that if it is only for those who only want to get benefit from the agreement without any, then no concessions will be granted to such entities by Korea. And I think we can refer to Article 26, which limits. This is the section about limitations on benefits. So you're saying that if some Hong Kong residents may not directly hold that, but if they hold them indirectly through certain entities, of course they will need to hold sufficient quantity of such bonds, then he can try, it would appear, the tax rate on bond yield is reduced from 14 to 10%. If the person wants to make use of this concession, should he apply to the Korean tax authorities and submit his justification? Well, generally speaking, if that fund is a Hong Kong tax resident, and if that unit trust receives dividends from Korea or interest from Korea, it can directly ask the Korean tax authorities to charge a reduced rate of tax. And if necessary, the fund, which is a tax resident in Hong Kong, can ask the IRD for a certificate of a tax resident. And then this will be forwarded to the tax authorities in Korea. If the authorities in Korea still have further questions, we can, communicate. Mr. Cheung, I also like to come back to the Korean agreement because we do have more trade, more transactions with Korea. I still like to, ask about the definition of resident. When talking about partnership, and if we look at Article 3(1)(f), of course the definition of person includes corporations, a trust, and a partnership. So I like to ask the authorities this question: if it is a partnership, would you look at whether or not how would you judge whether the partner is a Hong Kong resident? Mr. Chiu, thank you. In determining whether or not a partner is in control of the fund in Hong Kong or managing the fund, one would need to look at the local legislation of Hong Kong, because management and control, I think we follow the case law in Hong Kong, in the UK, to determine whether or not enterprise is being managed or controlled in Hong Kong. For a limited company, for example, very often we would look at the board of directors. If the board of directors really indeed exercises indeed manages and controls the fund and makes decisions in regard to the fund, then we will look at these partners to see whether or not they make all the important commercial decisions and management decisions in Hong Kong. Recently, at the G20 and OECD meetings, members are concerned about the transfer pricing adjustment. But in this agreement, there is no article dealing with transfer pricing, the question of transfer pricing and corresponding adjustment. Do you have such an article? And if so, how is it directly related with to the strategies of the OECD and the G20? In the agreement with Korea, under Article 29, there is a reference to related entity, which allows both parties to make adjustments The adjustments referred to by the member is mentioned in paragraph 2, third line from the bottom, appropriate adjustment. So Article 9 would allow for transfer pricing adjustments. If one party has made the primary adjustment, the other party will have to also make the corresponding adjustment. So in other words, based on the tax rates in Hong Kong and Korea, they would adjust their profits accordingly. And it is stipulated here that they are allowed to do that. Chairman, the so-called connected party, we're talking about two connected entities, for example, belong to the same group. Supposing they have certain transactions and the pricing is not based on the market price, then the controller for both parties may make adjustments according to their own respective laws. So they would not set the price according to the market level. So what it means is that the transfer pricing, which is not based on the market price, then the two tax authorities may make the adjustments according to what is appropriate. In other words, they can disregard the transfer pricing.
即係有處理嘅，
冇問題啦。咁樣
So this issue has been dealt with. Oh, thank you, Chairman. And then concerning the Vietnam order, it is it's an updated version of the previous one. Because the agreement was signed in 2008. And let me give an example. Is it that you've updated the Vietnamese agreement to meet the latest standards? Say, for example, is the Vietnamese order similar to the Korean order? Is it that only one point in the Vietnamese agreement has been updated? Chairman, basically, all the provisions on EOI have been updated. In fact, members can refer to paragraph 5 of the electoral brief on the Vietnam order. So the safeguards mentioned just now in the electoral brief on the Korean order are also incorporated into the Vietnamese order. What about aviation, sports, and so on and so forth? Now, those provisions have not been updated. We're just updating the EOI provisions in order that they can converge with international standards. So the agreement with Vietnam was signed 6 years ago. The country has opened up since then, and we now have more countries investing in Vietnam, more companies, investing in Vietnam. How come we're not updating the provisions in other respects? Now, we've signed 31 CDTAs so far, Chairman, and they have been in operation for some time. As the tax authority in Hong Kong, the IRD regularly reviews such CDTAs to see whether updates and enhancements are necessary. And of course, the IRD takes into account the views of the sector. Mr. Chiu can supplement later, but my understanding is that with regard to the Vietnamese order, we haven't noticed any provision which requires updating apart from the provision on EOI. Now, Chairman, the Vietnamese authorities have not indicated to us a wish to change the arrangements under the protocol. It's true that the IRD receives some comments from the industry, and we will study them and see whether we need to take action in response. Now, concerning the latest version, in fact, the Chambers of Commerce, including the Vietnamese Chamber of Commerce, was informed of your intention to change the EOI provisions, and you've suggested that if they had anything to propose in order to change the 2008 protocol, they would have raised the matter with you. But I want to say that in some cases you may only wish to update the EOI mechanism. In other cases, more changes may be contemplated. And so I think you should tell the business sector, the chambers of commerce, that they are welcome to give suggestions on other changes to the agreements. So even if you merely want to change provisions on EOI, they may take advantage of the exercise to give other suggestions on other changes to the agreement. So I think our government should take a more proactive approach in inviting comments, because I understand that, in fact, more local companies have been investing in Vietnam in recent years. Yes, Chairman, thank you for your advice. In fact, we do send out invitations for public comments on our website, and also there is the joint taxation liaison group comprising representatives from the HKIP, CA, from tax practitioners, and chambers of commerce. And so if there are areas in certain agreements which require changes or clarification, such views are also reflected in the liaison group. But then the liaison group covers a very wide range of taxation matters. But also it's a too big a platform for individual chambers of commerce or countries to give specific suggestions on their respective protocols or agreements. So I think you should proactively try to seek their views. All right, members, do you have any further questions?
如果冇嘅咧，就OK 㗎啦，係嘛
？No more questions?
我諗都唔需要啦，使唔使啊？有冇啲因為我假設如果係咪一啲好
I think I can assume that you will draw our attention to extraordinary provisions or articles, so to speak. All right, legal advisor. The legal advisor has asked us to err on the safe side and go through the orders. All right, let's go through the Vietnamese order first.
主席，你意思係嗰個標明文本
Chairman, are you referring to the marked up copy? Yes. Page 1, 0001. In fact, this is under Section 49 1A of the Ordinance. And in para 2, you can see a new subsection 2. And so the original paragraph is renumbered paragraph 1. And here we say, for the purposes of Section 49 1A of the Ordinance, it is declared that the arrangements specified have been made with Vietnam, and that it is expedient that those arrangements should have effect. All right, and then page 2. Why is it that there is the reference to being expedient that the arrangements should have effect? Section 49 of the IRO states that the premise for putting in place the arrangements is that it is expedient, that the arrangements are beneficial and thus should have effect. But then some may have to pay more and some less. I'm talking about the general situation. And where does it say that it is expedient that the arrangements should have effect? In the IRO, it is stated that such arrangements are put in place when it is expedient that the arrangements should have effect. So it's 49(1) capital A. So someone has to come to the judgment that it is expedient that the arrangements should have effect, all right? And that someone should be the controller. All right, page 2 of the marked up copy. First of all, some renumbering. Because as the second protocol has been signed, it becomes Section 3(2). So in other words, the provisions are in Schedule 2, and and in fact the agreement has been signed. And and Schedule 1. Or the original schedule is number Schedule 1, and it relates to the 2008 protocol. And then you can see Schedule 2 on page 4. So it talks about Article 25 on EOI arrangements. And the existing provisions will be replaced by the provisions in, or the arrangements in Schedule 2. And these arrangements are in line with the arrangements in other CDPAs.
I don't quite understand why under Section 1, bracket 3, Part 1, you talk about secrets, commercial secrets, and then you talk about providing information which is in violation of public policy or public order. What does that mean? Well, Chairman, I think in the OECD template, this is a standard provision, and it has consistently been found in our other agreements. What do they refer to? Let's say if it is in conflict with your public policy, then the signatory party will not have an obligation to exchange the information. Has there been any refusal for information to supply the information? The bracket said order public, which is a French term. Translated into English, it means public policy. In other words, in the course of exchanging information, if it is in breach of any public policy, then the signatory can refuse to exchange such information. The most obvious example will be matters relating to national defense. Okay. Okay. Well, in that case, it may involve matters relating to national defense industry. So what is the procedure? Let's say, well, in Hong Kong, there had been a case where the SFC required a certain auditor to declare certain text manuscripts or drafts, and the auditor said that it involves national security in China. Eventually, the SFC took the case to court, and the court ruled that the entity has to provide such information. Here, we're talking about an exchange between tax authorities. If we adopt this reason and exchange information, does it mean that the tax resident would have to bring it up with the tax authorities before they could, invoke this reason? Well, Chairman, this provision is already an international standard. In the 31 agreements we've signed with other jurisdictions, the same provision is there. But if we adopt the normal approach, when we receive a request from an overseas tax authorities, we will remind them whether or not the request is in compliance with the terms of the agreement and also our own Hong Kong disclosure rules, and that whether or not it is relevant to tax collection. If the answer is yes, and if such a problem does arise, then the party concerned will have to inform us. We would also have to check whether or not there is any breach of this provision. And if so, we have to inform the tax authorities in the other jurisdiction why we hold this view. So you can order the person who possesses such information or the taxpayer who has such information, declaring that it's commercial secrets or something related to public policy or national defense. They will give you such reasons, and then you will make a judgment. And if you also agree that it is in compliance with the agreement, then you would refuse to provide exchange information. All right, the taxpayer in Hong Kong will give us their views. We will also make our own judgment, and then we would inform the tax authorities on the other side about our judgment. If the two parties don't agree, is there a mechanism to resolve that? According to the agreement, there is a mutual agreement procedure. Both parties can sit down and discuss this further and before coming to a conclusion. If the taxpayer thinks that this involves, important business secrets, he doesn't even want to inform the IRD. He simply would say that this is a secret. Then you'll be stuck. Well, Chairman, in my experience, I've not come across such a scenario. And if that scenario should arise, I think I would need to find out how the law empowers us to do what. Thank you. Please carry on. Chairman, Schedule 2 will go all the way to page 9. So that's the end of the order. Do colleagues have any other questions? If not, shall we go on to the Korean order? Okay, I think we can also go through the Korean order. Chairman, for the Korean order, this is a brand new agreement, and the formulation, first of all, it is based on the OECD template. We started a negotiation on that basis, and at the beginning we would make, we talk, you'll find the commencement date, and again we have made a judgment declaration saying that we've now come up with this agreement, and such arrangements would include the entire agreement. We've signed with Korea, and then we've signed a protocol. The relevant provisions will be contained in Schedule 1, Part 1, and Schedule 2. Well, the treaty is signed in Chinese, English, and Korean. Which would be the official version? Would it be the English version? My understanding is that there is no authoritative version. So all three versions would be considered authoritative, yes. Please move on. Section 1 is it's about what will be covered by the agreement, and second is the second provision spell out the taxes covered. Section 3 is about definition of terms. I'm sorry, I have a question on this. I understand that in Korea they have certain territorial disputes with neighboring countries. In B, for example, you talk about, say, should there be any dispute between Korea and Japan? According to this agreement, whatever is considered to be Korean territory, if Hong Kong residents work there for more than 183 days, then they have to, pay tax accordingly. If Japan also claims that to be its own territory, and we sign another tax agreement with Japan, and then so in case of an overlap, it wouldn't be the case that both jurisdictions, Korea and Japan, will impose taxes. Because for such territorial disputes, I think we should only stand to benefit. If we have one additional agreement, there is no risk that the taxpayer will be subject to double taxation. Chairman, regarding the Korean order, in Article 3(1)(b), it is said that it basically is based on international law. So if the territory or the ocean belongs to Korea, we would consider that to be a part of Korea. That would really be quite tricky. The international law may only recognize the sovereignty over a particular territory, but sometimes we have to decide which order we should invoke. Then our own tax authorities may have to find out under the international law which order we should follow to give the waivers. I think this formulation is already the typical international draft. In the course of the negotiation, normally we would always follow this practice. Perhaps our colleagues from the DFJ could further explain. Thank you. Understanding is that according to international law, we are talking about the international defines the territories of different countries. Other than looking at the international law, we also say that we're talking about any territories over which the Korean Republic exercises sovereignty. So we are combining the two. We're not saying that we should, in deciding what is Korean territory, we'd only refer to the international law. The territory of a particular country is not just defined by international law, but also by the laws of the land concerned. According to Mr. Chiu, apparently the countries who have signed these agreements with, I don't know whether or not such disputes had ever arisen, where there is a conflict between international law and the local legislation concerned. I don't know whether there had any been such conflict, and if there were, then one would need to look at each case on its own merit. Would it be possible that there may be a country which has territorial disputes with our own country, and there are certain economic activities there which involves a tax liability? So when we sign such agreements, do we stipulate that in these disputed territories they will not be covered by the waiver arrangements? Because we want to get the waivers. If a particular country, I don't know whether or not Korea has any territorial disputes with China. If in case we have people from Hong Kong working there, of course we will respect our own national legislation, and we try to get a maximum tax benefits for our own residents. So perhaps you may need to pay attention to this possibility, because I don't want to ask you about your position on this. It has to do, it may involve the one country, two system scenario. But but just because I thought I can think of this scenario, I think there's a possibility that it may arise. But for these disputed territories, I don't think there would be much economic activities unless you're talking about, drilling for oil. But anyways, please pay attention to this possible scenario in future. So when we negotiate with any counterparty, we need to be careful. Okay, please carry on. Article 4 and 5 about definition of residence, and also and 6 and 7 in dealing with income arising from aviation, capital income, income from employment, artists, athletes, all pension. I think we are all the way to Article 20. It's about how do we deal with the tax jurisdictions, whether not only one party has the right to collect tax, or both parties. So I think in Annex C of the electrical brief, we have outlined these the way in respect of the different types of incomes and who has the right to collect tax. Article 21 and 22 and 23 is also standing provisions in the OECD agreement. That is, how do we deal with the question of double taxation? For Korea, we will provide exemption from double taxation for our respective residents. And where there are particular cases where the two jurisdictions do not agree, then there is a mechanism for both sides to sit down and try to negotiate before coming to certain agreements. Article 24, I think we've already discussed this in detail. Basically, this is about the exchange of information arrangement pursuant to the international standard, and and the safeguard measures that we have adopted all along in Hong Kong. And Article 25 and 26 are about are actually contained in some of the existing agreements. Article 26 was already alluded to by Mr. Chiu. That is, if you only just for the purpose of tax purposes, then both parties may rule that you will not be entitled to the tax benefits contained in both agreements. And Article 27 is the entry into force agreement, and both parties will enact local legislation and inform the other party respectively, and also informing the other party of the commencement date. Article 28 is determination clause, and this is again found in other CDTAs. Part 2 is the protocol, which is also signed at the same time. And in the protocol, spell out which provisions need more detailed interpretation. In Section 1, it is said that the two parties can have a mechanism for review once, say, every 5 years to see whether or not there are certain parts of these agreements which needed to be updated. In clauses 2 and 3 and 4, spell out clearly which are the tax items which will not be included, and also what are the transitional arrangements in respect of income from aviation business. For airline companies, if they're based in Hong Kong, then they will pay Hong Kong taxes. Article 24, namely paragraph 6, reflects Rule 4 of the disclosure of information. That is, if the Korean authorities provides information to the Hong Kong authorities, it has to be about the matters which is relevant for a taxable period or a taxable event following that date.
嗰度咧
Concerning 4.2, is it that you first of all look at whether there is a permanent home, and then you look at the right of abode and so on and so forth? Yes. But then concerning a place or a live a residence where can be used permanently. So he may want to buy the flat if the amount of tax is to be paid is very big. All right, so we've completed the scrutiny. If members don't have any further questions, so the clerk, can you remind us of the timetable, please? Yes, thank you. The two orders are to take effect on the 12th of December. At the last meeting, members agreed that the scrutiny period be extended to the 10th of December. And tomorrow, the chairman will move a motion in the meeting of the whole council to extend the scrutiny period to the 10th of December, and will report to House Committee on the 28th of November. So if we do not extend the scrutiny period, then in fact we should have reported to the House Committee on the 7th, and today is the 11th. All right, so I think the only outstanding task is to report to the House Committee. All right, no further questions, then meeting adjourned. Thank you.